What would you do if you knew someone was coming to take something away from you? Something that you know you are entitled to by virtue of being a child of God, a human being, a citizen of this country? Would you sit back, watch them and let them take it? Or would you speak up? Would you take any action? Hi, I am Lawyer Dora. Welcome to Let's Talk Law Kenya.
There's always been a passion to inform people about the laws that we have, the loopholes, the ways to maneuver everyday activities in your business in line with the law so that you succeed.
Access to healthcare is an inherent human right, and it is protected in international treaties. It is enshrined in our constitution. But here's the thing. So many of us struggle just to afford basic medical treatment. How many times have you heard of people saying, oh, we need to do a harambe, we need to raise funds so that we can pay so-and-so's medical bill. You know, people sell land, people sell their property just to be able to afford healthcare. Even emergency treatment, people are stopped at the door if you don't have money. And it's a very unfortunate thing. So in response to this, the government said, okay, we're going to introduce something called universal healthcare, universal health coverage, however you want to call it. And granted, this is something that's long overdue in our country, but the way it is being introduced raises a lot of questions. Let's start from the beginning. Now, on 19th October 2023, the president signed into law the new Kenyan health laws, and they came as a 4-in-1 package. And this was the Social Health Insurance Act, the Primary Healthcare Act, the Digital Health Act, and the Facilities Improvement Funding Act. Big ambitions, right? Now, if you want to know more about what these laws are and why and how they are interconnected, I would urge you to read an article written by a very lovely, sharp lady called Advocate Doram Seketi, and it's linked down below. I actually started researching this thing and writing a series on the new Kenyan health laws. The interconnectedness of the 4 new health laws is outlined in Understanding the New Health Laws Part 1, which is part 1 of the series. Anyway, moving on. So they introduced these new health laws, and it was like, yeah, this is going to change things. In fact, the Social Health Insurance Act defines universal healthcare as access to any health service needed by all individuals and communities without enduring hardship. It's supposed to mean that everyone from every corner of this country should be able to access the medical services, the health services that they need. And they should be able to do this in a way that does not hurt their pocket. Interesting. Good news, isn't it? Yeah. What happened is, in November 2023, upon the insistence of some very patriotic Kenyans, the High Court said, government, I see what you're trying to do, bring about universal healthcare, but we must protect the rights of the citizens in this country. And for that reason, we are suspending the implementation of these new laws until 7th February 2024, because we need time to sit and ponder over the questions that these patriotic Kenyans have raised in this court today. And you could almost feel the disappointment of the government's representatives in that courtroom that day. But it could not trump the relief of the patriotic citizens as they left there knowing justice had been served and rights have been protected. That relief was short-lived because in January of 2024, Court of Appeal said, listen, government, we have heard you and we understand that progress must be made. And for that reason, we say, okay, go ahead and implement these new laws. But we prevent you from implementing 3 provisions of the Social Health Insurance Act. So before we go over what these 3 provisions that are hanging in legal limbo are, I want us to just quickly go over a few things, okay? So 1, the Social Health Insurance Act, or the SHIF, if you will, it repeals the NHIF Act, and then it introduces the Social Health Authority and the Social Health Insurance Fund, or SHIF or SHIF, if you will, which will replace the NHIF, the National Health Insurance Fund. Now, the other thing I'd like us to note is, other than the SHIF, this act introduces 2 other new funds. That will be the Primary Healthcare Fund and the Emergency, Chronic and Critical Illnesses Fund. This fund is supposed to provide financial assistance for the management of chronic illnesses in instances where the social health insurance cover has been exhausted. So if you or someone you know is suffering from a chronic illnesses and you have completely depleted your resources as allocated by the SHIF, then the government is supposed to step in through this fund to help you cater for the cost of the treatment of that chronic illnesses. The other thing is, this fund is supposed to cover emergency treatment costs, which is going to align with the Article 42 of the Constitution, which says that no one should be denied emergency medical treatment, even though we know it happens. But now with this fund, the government is going to take the initiative to cover for emergency medical treatment, which means no hospital should have the audacity to chase you away or someone you know if you need emergency medical treatment or care. The other thing I wanted to note real quick about the Social Health Insurance Fund. This is where it gets interesting a little bit. Now, you already know that they want 2.75% of your salary or a minimum contribution of 300 Kenya shillings. By virtue of you being an adult over 25 years of age, you are required to contribute to the Social Health Insurance Fund. It is mandatory. Make peace. Okay. And then now, whether or not you are employed in the formal sector, they still want 2.75% of your income. Before, under the NHIF, they didn't really say that people in the informal sector must contribute to the fund. In fact, if we check our history correctly, before 1972, NHIF was primarily a reserve for people employed in the formal sector. Now, in 1972, they introduced the option for people in the informal sector to make contributions towards the fund if they so wished. It was voluntary. But now, after the enactment of the Social Health Insurance Act, contributions to the Social Health Insurance Fund, or SHIF or SHIF, are mandatory for every Kenyan adult above the age of 25, with minimum contributions of 300 Kenya shillings each, whether or not you are employed. If you're not able to contribute, the Social Health Insurance Act has made provision to require the national and county governments to make contributions on behalf of people who are not able to do that themselves. People who are experiencing extreme financial hardship, the indigent, as they call it in the Act, the extremely poor, are supposed to have their contributions made on their behalf by the county and national governments. Okay, interesting initiative. As the government promises to make contributions on behalf of those who do not have the financial resources, some questions arise because there was a recent report by Infotrack which said that 73% of Kenyans are grappling with severe financial distress or finding it challenging to meet their basic needs. So now this brings the question, is our government ready? Does it have the capacity to cover the contributions of 73% of Kenyans? The government says they're going to provide financial products to support people who are not extremely poor but don't have enough money to pay for the Social Health Insurance Fund premiums. And now the question arises, what exactly are these financing products? And I'm just left to question, I hope they don't mean they're going to give us loans so that we can pay for something they're forcing us to pay for, and then we have to pay them back. And I had some optimism that there is no way our government will try to pull such a move on us, right? My optimism was short-lived. The Ministry of Health shared an infographic, and that infographic informed us that contributors working in the informal sector would be responsible for an annual premium payment, of course, as stipulated by the Social Health Insurance Act, and they will have an opportunity from the Hustler Fund and cooperatives. Are you hearing this? If you are in the informal sector, you're going to be paying your premiums annually, not like the ones who are employed in the formal sector paying their premiums monthly. And as you pay your annual premiums, if you can't afford to pay your annual premiums, the government is going to come and help you. And how will they help you? By giving you a loan from the Hustler Fund and or cooperatives so that you can be able to pay your Social Health Insurance Fund premiums. And then later on come and pay the government for the loan they gave you to pay the premium that you are forced to pay because you must be registered. Are you seeing the ridiculousness of all this? To determine how much you're going to pay for your annual premium, if you're in the informal sector, they're going to apply something called means testing, using a means testing instrument, which is basically them using some certain indicators and parameters to try and see how much are you capable of having so that they can see how much you're capable of paying. And I outlined all this together with all the three funds, their functions, their purpose, and the Social Health Authority as well in the article called Understanding the New Health Laws Part 2 of the series I had earlier mentioned, and it is linked down below as well. What rationale is there in compelling citizens in the informal sector to make contributions to this SHIF, making them take loan, be able to pay this? How can you you be so cruel to your citizens? It's ridiculous. Let's get back to the topic at hand. The 3 provisions that have been put in legal limbo by the Court of Appeal. Now, on 19th January 2024, the Court of Appeal overturned the High Court's conservatory order that had been issued in November of 2023. And in doing so, the Court of Appeal has allowed for the partial implementation of the Social Health Insurance Act together with the 3 other acts. The implementation is partial because there are 3 key provisions of the Social Health Insurance Act that shall remain under legal scrutiny until determination. And these key provisions are provision number 1, Section 26(5) of the Social Health Insurance Act. Now, Section 26 is going to make registration and contribution to the Social Health Insurance Fund a condition that you must meet before you can access public services from national and the county governments or any of their entities. What does this mean? If you're not registered and fully paid up to the SHIF, then no birth certificate for your baby, no renewing your driver's license, no passport for you, no government services of any kind at the national and county level. Second provision, Section 27(4) of the Social Health Insurance says that you can only access healthcare services if you are registered to and fully paid up in the Social Health Insurance Fund. Take a moment and ponder. You have been forced to be registered to the SHIF. On top of that, if you're not fully paid up, you cannot access healthcare services. As you ponder that, let's go to the 3rd provision. And this is Section 47(3), which says every Kenyan must have a unique digital identifier for them to be registered to the SHIF. Of course, balancing the need for universal healthcare with citizens' rights is a delicate matter. On one hand, the government wants to ensure health coverage for all. On the other hand, citizens might feel that our rights are constrained when access to healthcare and essential services has been made conditional to our payments in the SHIF. So which of our rights are going to be infringed upon if these 3 provisions are allowed to be implemented? Our right to health is enshrined in the Constitution under Article 42. And it says that every Kenyan citizen has the right to attain the high standard of medical care. Under the Social Health Insurance Act, access to healthcare services is conditional upon maintaining an up-to-date contributions with the SHIF. Our right to health in the Constitution is not conditional. Why in the world would the government think that they can put a condition to access to healthcare in the Social Health Insurance Act under the guise of providing universal health care? If your pocket is dry, if for whatever reason you are not up to date with your SHIF payments, you will be unable to access the healthcare and treatment and services that you may need or require. Anytime you fail to pay up to this SHIF, if you have outstanding payments, you will not be able to access healthcare services until you have made all the payments that are required. This requirement is going to encroach upon our right to health. This is a right that is not conditioned by the Constitution. This raises questions of the fairness and practicality of the system that the government is trying to implement, restricting access to healthcare services based on the payment status of someone to the SHIF. It seems contradictory to the objective of the Social Health Insurance Act to promote universal access to healthcare services in a way that does not leave your pockets dry. If you can't make your payments to the SHIF, you can't access healthcare services. Doesn't this mean that healthcare services will be a reserve for the wealthy? If you are poor and you are sick, just die. And if you listen to Nabii Ruto, it gets worse because he says if you are poor and you are sick, you will not only just die, but you will go to hell as well. Because according to our president, if you fail to make payments to the Social Health Insurance Fund, that is an automatic hell ticket for you.
Usiwe mchoyo ukasema inakuhusu nini ati wewe uchangie tuweze kumlipia yule ambaye hana uwezo. Kuna mahali inakuhusu kwa sababu utasimama mbele ya Mungu siku moja. Utaambiwa wewe ulikuwa na uwezo ya kucontribute 2.7%, ulikataa. Yule ambaye alikuwa mgonjwa hakusaidika, wewe utaenda jehanamu.
I would like to point Nabii Ruto towards Proverbs chapter 17 verse 5, King James Version. And it says, Whoso mocketh the poor reproacheth his maker, and he that is glad at calamities shall not be unpunished. You are mocking the poor, sir, by telling them that since they cannot afford to make payments into something that you have forced them to be a part of, then they will go to hell. And not only that, you seem to be rejoicing at the calamity of what? Poverty. Poverty is a calamity in this country as far as we're concerned, because you're acting like you do not care at all about the plight of many Kenyans. You seem very disconnected from the harsh realities that most of us are facing. But since you claim to be a man of God, familiarize yourself with Proverbs chapter 17, verse 5. Now, saying that the poor and those who cannot make payments cannot access health services, doesn't this mean that it's going to infringe upon the right to equity and freedom from discrimination? Because basically you're saying these health services are going to be a reserve for the wealthy. You're also saying that if you're not paid up to the SHIF, you cannot access government services at the national and county level. How in the world are you going to make it a condition for your citizens to access services that they should freely access by virtue of being a citizen, and say they won't access it unless they make payments to something that you have forced them to be a part of? This keeps making less and less sense the more we get into it. It makes zero sense. Article 27 of the Constitution emphasizes equality before the law, and it asserts the right to equal protection and benefits without discrimination on whatever ground: race, sex, religion, health status, no discrimination at all. So how is the government coming to discriminate against those who do not have enough money? Tell them they can't access healthcare, can't access government services. Zero sense. The national values aligned in Article 10 of our Constitution outline principles including human dignity, equity, social justice, inclusiveness, equality, human rights, and non-discrimination. And these constitutional provisions, all of them together, highlight the significance of addressing the needs of vulnerable groups in our society. In saying that those who cannot afford to make payments to the SHIF will not access healthcare and will not access government services at the county and national level, you have infringed upon the right to health. Now you're infringing upon the right to equity and freedom from discrimination. And on top of that, you're going against the Social Health Insurance Act objective, which emphasizes the principles of solidarity, of equity, and efficiency. So why all these contradictions with the Constitution and with new health laws themselves? Like, who exactly are these laws meant to benefit? Article 21 of the Constitution mandates that in the implementation of rights and freedoms, all state organs and public officers have the duty to address the needs of vulnerable groups. This underscores the legal obligation to safeguard against discrimination and promote equal access to essential services for all citizens. By virtue of this, Section 26(5) of the Social Health Insurance Act that says you must be paid up to the SHIF to access government services, and Section 27(4) of the same act that says that you can only access healthcare services if your contributions to the SHIF are current and up to date, then those by law should not even exist. But it's not just your right to health and your right to equity and freedom from discrimination that are going to be affected. It's going to also infringe upon your right to privacy. As we delve into the realm of health insurance, it becomes important to address the intricacies of personal health information that is going to be handled. The legal landscape surrounding data protection and privacy assumes a very critical role in safeguarding our privacy rights and ensuring the lawful handling of all health-related data. Under the Social Health Insurance Act, the government has conveyed their intention to digitize the whole health sector and everything it entails. Because of that, we now have the Digital Health Act, which is supposed now to come and lay down the law on how this is supposed to happen. The Digital Health Act introduces a paradigm where all health-related data, including your personal records, become accessible and stored by the government. Can you imagine? We already saw the e-citizen hack. We already saw that the people responsible for the e-citizen, is it the website, already said, oh no, we just licensed the platform to the government. We're not responsible for its security. Everyone is throwing blame here and there. No one wants to accept that they dropped the ball, which now made the site very hackable. Now, if that can happen to a very major government site like that, what's going to happen with very sensitive health-related data? Are you willing to bet that the government is going to have a handle on your privacy rights? According to the Digital Health Act, the digitization of this health sector is supposed to be done in alignment with all relevant laws such as the Data Protection Act and such. However, the interconnected nature of this data linking it across various government sectors and sites is going to raise concerns about the potential infringement of our right to privacy as enshrined in Article 31 of our Constitution. Because let me just paint this picture for you, okay? You want to apply for passport. Let's say you went through eCitizen. They tell you, ooh, pay this fee. Because, they introduced the fees for eCitizen if you want to access any service. So you pay your fee, you pay. Just one tiny problem. We can see here that you are not up to date with your payments to the SHIF. And for that reason, I'm sorry, we cannot process your passport for you. For them to be able to know whether or not you qualify to be able to access healthcare services or to access these government services, what's going to go on behind the scenes in the interlinking of this information, and how safe is it going to be? How is that data going to be handled, transferred, processed? And in doing so, how can we be sure that our privacy with such sensitive information is going to be safeguarded? These are the questions that the government is yet to answer. This highlights the necessity for very stringent data protection measures to prevent misuse of our health data, our very personal information. Article 31 of the Constitution says that we have the right to not have information relating to our private affairs unnecessarily exposed. And this becomes a focal point in evaluating the balance between public service accessibility and privacy protection. When researching this late last year, I thought to myself, the government wants for each one of us to have a unique digital identifier as a prerequisite for you to be registered in the Social Health Insurance Fund. It just seems as a way for them to try and force us to have that digital ID that we have refused many times. Remember the Huduma number? Late 2023, they were supposed to launch the Maisha number in December. The courts stopped that launch. Some human rights group and some patriotic Kenyans had gone to court and said, listen, you can't implement this. First of all, the government cannot ensure that it's going to be a simultaneous implementation across the country. We have children still learning under trees in some parts of the country. And here you are saying that you want all of us to have a digital ID. So much infrastructure is yet to be put in place just so people can function normally. Here you are saying you're going to digitize the whole health sector. And not only that, you want everyone to have a unique digital ID to be able to be part of this new health paradigm, this new universal health coverage. I'll be the first to admit, I thought the requirement to have a unique digital identifier was just a plot by the government to try and find a cunning way to still make us have a digital ID. In 2023, when the court stopped the launching of the Maisha number, the reason the court gave was that the government had failed to conduct a data impact assessment as required by the Data Protection Act. But I thought, if they implement this provision of the Social Health Insurance Act, then this government is going to say, being registered to the SHIF is mandatory for every Kenyan adult over 25, and they cannot be registered if they don't have this unique digital ID. So now we do need for this Maisha number to be launched. That is not going to be a problem because in February of 2024, the court said, hey, government, go ahead and implement the Maisha number initiative. Despite protests by digital rights organizations like Access Kenya and the Kenya Human Rights Commission, the government said, yeah, we looked at it and whatever, data impact assessment test be damned, the government can go ahead and give you this Maisha number. And this Maisha number is going to include a digital card, a digital ID, a unique personal identifier, a national master population register. Those are the things that it's going to encompass. I guess we should expect to be required to have this ID very soon. You must have it in order to be registered to the SHIF, which is also something else that you must do according to this government. I'm getting stressed. Are you stressed? I was stressed a long time ago. I've just been trying to hold it together. This is serious. This is crazy. Looking at all these things, what do you think of your rights that are going to be infringed? Your right to privacy, your right to equity and freedom from discrimination, and your right to health. If these three provisions are implemented, there's going to be a lot of people going to court, me first among them, to complain about how these rights have been infringed. Can you imagine how many people are going to be willing to do that? And this is why Senator Ledama at some point said the same thing on TV. And I know that flew over people's heads because they thought he's just yapping as politicians do, just to get people riled up against these new health laws that are bringing us universal health coverage. You can all have access to healthcare, no detriment to our pockets. But then now you can see how and why he came to that conclusion. And the other thing that you must know is that these provisions can only be implemented if the government provides reasonable, convincing justification that shows that the outcome of the infringement of these rights far outweighs the inconvenience caused. This is stipulated by the Constitution, so it is something the government must do. I am keen to see just what kind of justification the government is going to present to our courts in order to try and convince the courts to allow for the implementation of these three provisions, despite the very real threat of infringement of our rights, our fundamental rights and freedoms. I'm keen to see. What do you think about this? Are you riled up? Are you okay with it? Are you, no, I'm just waiting to see. But personally, I think it's very nonsensical the way these provisions were drafted. It feels like there was no proper research done. It was rushed. They did not get proper advice. They did not research the effects of such a thing, because if they had, then they would have already seen the danger to our rights as we have outlined them in this video, and they would have known better than to include those provisions as they are in the Act. Did they think we would just let them fly? We need to stand up for ourselves and our rights. We should not allow this to happen, and we should follow those court proceedings very keenly. Going forward, there's still a lot to look into when it comes to those new health laws. There are, of course, countries across the world that have tried or have implemented something similar when it comes to their health sector. They have universal health coverage, and there are countries that have insurance schemes, have made them mandatory, and have linked social health insurance schemes to government services like our government is trying to do. Although I must mention that in some of those countries, they have limited the extent of the limitation on the services that you can access. And I think maybe we can explore this in a later video. It will definitely be in the part 4 of our series, and it will be published soon. You shall also make recommendations as to how the government can try to implement this in a way that is not detrimental to the rights and the welfare of all citizens. Let me know what you think, what you feel in the comments. Share this with someone so that they can get as riled up as you and I are at this point. Like, the engagement helps a lot. Then subscribe so that you do not miss out on the next video. Follow us on Instagram, on TikTok, on Twitter, where we share legal content and information for various formats. In fact, I recently shared about the similarities between these new health laws and our Kenyan succession laws on X. So make sure you take a look at that. It's also linked in the description box below. Now that you have found Let's Talk Law Kenya, you have found your legal compass. And as we sail these legal seas, you will never be lost again. Thank you so much for watching.